Case studies. In May 2013, a staff from a direct selling company visited Mr. Goh's residence to do a cleaning demonstration for his existing kitchenware. Subsequently, the staff promoted her company's products to him. Eventually, Mr. Goh agreed to purchase a 28 cm low saucepan. The cost was $950 after a trade-in of $900 for one of Mr. Goh's pots. Mr. Goh paid a deposit of $475. At the point of purchase, he was not informed of his rights to cancel the agreement within the cooling off period of 5 days. Mr. Goh is now aware of the provision and would like to cancel the agreement and request for a refund of $475. The case was reported and the company was informed that they may have infringed the CPFDA, Cancellation of Contracts Regulations 2009, failure to inform or honour 5-day cooling off period for timeshare related and direct sales contracts made on or after 15 May 2009. The issue was resolved and the consumer agreed to use the deposit paid to exchange for a new saucepan. Second case study. Madam Ling engaged an agent to sell her property. In February 2013, it was agreed that the agent would allow her family to have an extra 2 months to source for another property to move. However, there was a postponement in the second appointment date. The agent did attend the subsequent meetings and there was no response despite Madam Ling's attempts to contact the agent. Madam Ling was made to evict her property urgently after the appointment, which resulted in extra costs incurred in transport, movers and rental for 2 months. Madam Ling was dissatisfied and requested for a reduction in commission. Case invited both parties to go for mediation and both parties agreed to a reduction of 50%, that is $4,500 on the commission paid as the final settlement. Case 3. On 26 August 2010, Mr. Tan engaged a renovation company to renovate his home for $34,180. He was given a 5 years warranty to cover defects. Around mid-2012, a pitcher of water was dropped onto the laminated flooring. Mr. Tan immediately tried to dry the flooring, but the water seeped through the joints. The flooring planks subsequently popped out and created sharp edges. The company refused to rectify the flooring for free, claiming that its waterproof property did not apply to the joints, and that Mr. Tan had left the water for over 5 hours. Mr. Tan found this reasoning unacceptable and requested for rectifications at no charge. Case emphasized to the company that they may have infringed on one of the unfair practices under the Consumer Protection Fair Trading Act, making false claims that a transaction involved goods or services has or does not have rights, remedies or obligation. The company agreed to settle the rectification works within 1 month. Case 4. In February 2014, Madam Rina visited a beauty salon for an eyebrow embroidery session. She specifically requested for the promotional $58 session, which was advertised on their Facebook page. The staff at the salon acknowledged her request and proceeded to do the treatment. After the treatment, the staff informed Madam Rina that the promotional $58 session had ended. Madam Rina was charged $406 for the treatment, which she disagreed, as the advertisement on Facebook had indicated that the promotion was valid until March 2014. Since the treatment was already done, Madam Rina had no choice but to pay $406 in protest. She requested for a refund of $350. Case contacted the business and they were advised that they may have infringed upon the Consumer Protection Act, making false claims that goods or services are available or available in particular quantities or prices. After negotiation, the business agreed to refund Madam Rina $350. Case number 5. In February 2013, Mr. Chi purchased an annual pass to watch football on the company's online portal. He paid $154.08. In July 2013, the subscription was suddenly terminated. The company claimed that the agreement had indicated that the validity of the pass was only for the 2012-2013 session and not for the 2013-2014 season. Mr. Chi felt misled as it was supposed to be an annual pass. He requested for a partial refund. The issue was highlighted to CASE, and the company was informed that they may have infringed upon the CPFDA Section 4A misleading claims, and the company was willing to provide a 50% refund. Please note that in all these case studies, that the surnames have been changed to ensure the privacy of the consumers. You can read more case studies from this website.